Welcome, everybody, to this webinar hosted by the 21st Century China Center. I'm Barry Naughton. I'm the So-Kwan Luk Chair of Chinese International Affairs at the School of Global Policy and Strategy. I want to let you know that with Mark Cohen's permission, our webinar is being recorded and will be available on our website, china.ucsd.edu. Please use the question and answer function on the bottom of your screen to submit your questions. After the talk is over, I'll be reading the questions that you submit to your speaker during the presentation. Today, we are especially delighted to have the distinguished guest, Mark Cohen, who has been for many years the to-go person to understand intellectual property rights in China. Mark right now is at UC Berkeley. He's a senior fellow and director of the Berkeley Center for Law and Technology Asia IP project. And he's also a non-resident scholar with our very own 21st Century China Center. Mark worked for many years with the Department of Commerce and the U.S. Patent and Trademark Office. And he worked in the U.S. Embassy in China for many years. At the Patent Office, he was the resident specialist on intellectual property rights issues relating to China, among many other things. Mark will present for about a half an hour, a little more than that, and afterwards we'll begin a conversation. Mark, welcome to UCSD. We're delighted to have you. Now, I understand, Mark, that you would like us to start out with a poll for the audience. There are 3 questions on this poll. So Simung, if you would show to everybody in the audience the 3-question poll, and Mark will use it. There we go. I see it. I see it, but I understand I'm not allowed to take this test. So those of you in the audience, please do answer the 3 questions.
So these questions are really intended to help me understand who you are as the audience and kind of the ideas you bring to the table on the nature of our problems or engagement with China on intellectual property. So let's see. First question, I believe that IP theft is 59% is a vague concept that captures a variety of actions, many of which involve IP, probably how I would vote. 23% is a well-defined legal concept, and 16% is not well-defined, but I know it when I see it. And it seems like a lot of people have opinions on that because only 2% said no opinion. United States losses due to IP theft, 43% difficult to calculate. I don't believe the numbers I've heard or seen, or I don't know. And 30% say between 100 billion to 1 trillion, 10% under 100 billion, 6% over 1 trillion. So wide range there, and 10% with no opinion. So I'm sorry, 1% with no opinion. I jumped around, I'm sorry. And then the second question is, in order to address IP theft, the United States should engage with China to address the issues by better than a majority. 41% engage with China on issues of common interest or where it would help American interests. So together, that's a 96% vote in favor of some form of engagement, 3% not engaged, 1% no opinion. And Barry, the reason I ask that question is I ask that question all the time in Berkeley. And generally, we also get a very high, we should engage response rate, even during the heyday of the Trump administration, where there was a lot of talk about decoupling and wasting our time with engagement. So I think the IP community, wherever they stand on losses of what is IP theft, tend to favor some kind of engagement, whether on a limited range of issues or even some of the issues we disagree on. So that's good as a good starting place. What I'm going to do now is walk you through a PowerPoint fairly quickly, but the PowerPoint will be made available to you and later. So if there's anything that you need to get further detail on, you'll be able to see it later at your own time. So the topic here is really a topic that I wanted to challenge myself with because it's something I think a great deal about. is whether the United States has unduly, unfairly, or inappropriately, excessively weaponized intellectual property as a tool in our engagement with China for a variety of reasons, or whether we have appropriately titrated it, whether we've picked up on all the issues, whether we've ignored some, and how can we better strategize around the role of IP in our engagement, not only in terms of the issues we raise, but how we raise it and how we organize ourselves. And we're going to go through 4 big topics. One is, and I have to kind of step back into a kind of academic hat, is underlying IP principles. I want to be sure that even for those of you who are not lawyers, who have not looked at these issues, we just understand some of the basic vocabulary, some of which has been badly used. And I think the question on IP theft and what it is points to that. What the Trump era brought to the table in terms of weaponization, whether these issues resonated in China or were actually strongly opposed, and the consequences of this kind of weaponized dialogue. This is actually a very broad topic, and you'll see that there are many areas that I bring up that are ripe for further research, discussion, engagement on. So one of the underlying principles we start with, and this is kind of restating the obvious, but never before, I think, in US history had intellectual property been the prime instigator in a major global trade war. We've had disputes with China before, we threatened tariff sanctions or other kinds of sanctions, but the Trump administration made it the prime motivator behind a much bigger global trade war that eventually implicated our farmers, a range of products, tariffs, effort to balance the deficit, et cetera. And it came at an odd time for those of us who observed the IP regime, because China, and we'll get into this later, has really remarkably improved its IP regime in the past 10 years. So you can really question why now? Maybe because of a competitive threat, maybe because there was more harm caused by what was remaining of the issues. And again, it brings to mind this question of whether IP was weaponized, whether it was overexploited through perhaps claims of IP theft or through incorporating into other policy delivery mechanisms like export controls and sanctions, a whole new range of areas where IP was incorporated, including FBI investigations. And what are the consequences of that? So in order to understand this, we're going to have to spend a few moments to get our vocabulary right. When we talk about intellectual property, we're actually talking about a fairly well-defined bundle of intangible rights. Some of these have a history that go back hundreds of years, some of them in conventions that go back 150 or more years. So it's a pretty well-defined concept. There's some gray areas on the periphery where there's a lot of latitude for different countries to pursue protection in different ways. But we're talking about things like patents, which are for inventions, not abstract ideas, where a violation is infringement, called infringement. Trademarks, brand protection, where typically if it's willful, it's called counterfeiting, a violation. Copyright, typically dealing with artistic creations, including software. We're talking about piracy of copyright. Trade secrets for non-disclosed confidential information. And then a bundle of other IP rights like design protection, geographical indications for wines and cheeses and the like, plant variety certificates, pharmaceutical clinical data. I could be getting into that so much, but there are a bundle of other rights. And we often hear about hacking. Hacking is not intellectual property. It can be used to steal trade secrets and copyrights, but fundamentally, it's a way of obtaining information. So it's not IP, although we'll see that it's frequently bundled up with IP discussions. When we talk about IP theft, which has been such a dominant aspect of the Trump administration engagement, although it predates Trump and it's being raised by the Biden people as well, there's really no legal definition. That was a question I asked first off. The FBI says that intellectual property theft involves robbing people of their ideas. Well, if you went back to my prior slide, you see that a patent can't protect an idea. E equals MC squared is not patentable. The laws of physics are not patentable. Those are abstract ideas. The Supreme Court and almost every other patent regime in the world doesn't protect abstract ideas. And the FBI also said proprietary products and parts. That's not necessarily an IP right either. Simply because you make it and it's distinctive doesn't mean it represents some kind of valuable advancement of the art, scientific achievement, or other creation that the IP rights protect. So the FBI doesn't even have a very good definition. In 2005, intellectual property theft was defined as piracy and counterfeiting, massive piracy and counterfeiting in congressional testimony. What is that? Well, if you go back to my prior slide, piracy means copyrights. Counterfeiting means trademarks or brands. Nothing here about patents, nothing here about technology, nothing about trade secrets. Okay, just to give you a sense of the evolution of American thought on IP theft. The Commission to Stop IP Theft, which has been very active, it consisted of former Ambassador Huntsman and former Director of National Security and others, came out with 2 reports on IP theft. And it says that it includes software and music piracy, economic espionage, et cetera. And they define 3 categories: counterfeit and pirated tangible goods, pirated software, and trade secret theft. Really interesting because piracy includes copyright, which includes software. So they're being redundant, and they threw in trade secrets, which, as you see, was not in the prior definitions of what constituted IP theft. So give you an idea, this is not a legal concept. Perhaps it's a political concept, perhaps it's an expression of American frustration, but IP theft really doesn't have a very clear set of legal boundaries around it. What about the loss? The other question I asked, the loss figures for IP theft. This is also really interesting. Someone can delve into this at greater length, not only how it was calculated, but how it's resonated in politics and in the media. So this Commission to Stop IP Theft in a 2017 report, the second report, estimated losses due to IP theft at $600 billion. And for them, it was counterfeit goods, pirated software, and theft of trade secrets. It did not incorporate patent infringement, good thing, but it did include hacking at $400 billion per year. Somehow, the 2 of them were related. I'm not sure how they calculated 400 billion and why they used the hacking number to support the IP theft number, but okay, they came up with 600 billion. Let's back up that number a little bit to give you a sense of where it came from. The number, and I was actually advising that commission in its 2013 report, and I had some differences of opinion with them about how it was calculated. The number was based originally on traffic globally in counterfeit and pirated goods, trademark infringing and copyright infringing goods. And the original data from the OECD calculated that at 5 to 7% of global trade. The U.S. Chamber of Commerce calculated it at 6 to 9% of global trade. This is around 2003 to 2007. In testimonies before Congress, the number was calculated at 6 to 9% based on the U.S. Chamber data. And in fact, one congressman rounded it up to 10%. 10% of all the goods in global trade in the world are infringing IP rights, particularly brands, trademarks, and copyrights. The OECD said, whoa, that's too high. They pulled the number out of their hat. And suddenly in 2008, it goes down to 1.9, a 79% reduction. And then in 2019, it went up to 2.5. That was after these prior loss figures. If you took the adjusted number, 1.9%, from the 9% it was originally calculated, you would have no longer $600 billion in losses that Donald Trump and others, including the State Department in a report from November, December last year, calculated due to IP theft. And you come up to a more modest, but nonetheless significant number of $136 billion, a 79% loss. We don't really know where these loss numbers are coming from. There seems to be a lot of double counting. there also seems to be some exclusion of important things like patent rights. We do know that some of the original foundational estimates were retracted by those who propounded them, namely the OECD, which reduced their data, their incidence data from 7% of global trade or 9% to 1.9. Big drop. Very consistent with Donald Trump's view of the world, who he often said that hyperbole, a little hyperbole never hurts. 136 to $600 billion. That sounds to me like a lot of hyperbole, perhaps, particularly if it starts a trade war, but keep it in mind for future purposes, something to think about. So what kind of IP can be stolen? What's the international consensus about what constitutes IP theft? Well, the TRIPS agreement, the WTO agreement regarding intellectual property, Article 61 says that every WTO member should have criminal procedures and penalties to address willful trademark counterfeiting or copyright piracy on a commercial scale. They can have penalties and procedures for other rights, but it's only willful trademark counterfeiting or copyright piracy for which criminal penalties are required. This is really important. You'll notice trade secrets are not in the TRIPS agreement in terms of requiring a criminal penalty. Moreover, it's only when it's willful on a commercial scale that there's a criminal penalty. Moreover, patent infringement is not a subject of criminal enforcement under the TRIPS agreement, nor is it under US law, nor is it in the law of most developing countries. Technology is complicated. To say that you need to have a criminal remedy to address it, that is being stolen, would require a very high level of a burden of proof to know that you understood the technology, very hard to enforce criminally. So we mostly do this through civil procedures. And in fact, the TRIPS agreement also says quite clearly that intellectual property rights are private rights, meaning they're privately enforced, and that with respect to every intellectual property right, the way to protect them, Article 42, is to have available civil judicial procedures. US practice, longstanding US practice, our own Department of Justice says, furthermore, that the only time they would bring a criminal case is if there is not an adequate civil remedy. So really important, I think, to understand that when we talk about intellectual property, we're primarily talking about civil remedies, civil courts, not about criminal penalties. And there are a lot of reasons for that. The criminal process plays a very important role, but in US practice and most of the developed world, the civil practice is predominant, in some cases exclusive, especially with respect to technical IP issues. So again, what is IP theft? If we're only limiting it to thievery, to criminal activity, it's a very small sliver of the world of intellectual property. In fact, even in terms of government resources, criminal case numbers, US Department of Justice, 2019, fiscal year 2019, 68 criminal IP cases. It's a sliver of the US civil docket, which perhaps was 10,000 that year, maybe more, but it's a very small cohort of cases that are brought involving criminal intellectual property. Compare that to China. This data just recently released from China's Supreme People's Procuratorate, very similar to the Department of Justice. It's the agency that prosecutes IP crimes or any crime. And they litigated 23,000 cases involving 45,000 people for intellectual property criminal activity, which was roughly 67 times more criminal cases based on the 5-year average compared to fiscal year 2009 US data. So really interesting. We accuse China of IP theft. And part of that is not having enough of an adequate criminal remedy to deal with things like trade secret misappropriation, counterfeiting, or piracy. Yet in fact, China has 67 times more criminal cases than the United States based on this comparison. It's varied from year to year, but generally Chinese cases are at least the double digits times US criminal cases. Okay, so that gives you an idea of the magnitude of the issue around what is stealing IP, how big a problem is it, how do we define it, How does it fit in, and how do we align it with our own values? What did the Trump era bring to this discussion? Well, the 301 investigation, which launched the trade war, which said that there was $600 billion in losses due to IP theft, was launched with this report that was published in March of 2018. Let's keep that date in mind for later on. August 2017 launched, final report, March 2018. And basically, the concerns were over forced technology transfer and other IP-related issues, and especially the consequences of estate planning and interference in market decisions of enterprises that wanted to transfer technology or not transfer technology, and of the Chinese government trying to acquire technology appropriately and inappropriately, including through cyber influence. And the consequences of that report were significant. We had retaliatory tariffs, which continue to this day, and the Biden administration has not yet said it would back off from those tariffs. We had counter retaliation by China. DOJ launched a China initiative to deal with economic espionage cases, and some people have accused our own Department of Justice of bias. Export controls were tightened up to limit China's ability to acquire technology and to also punish those who are violated. Huawei being placed on the entity list, ZTE threatened with it as well. We've seen TikTok and Tencent as well having issues. Foreign investment was restricted, et cetera. So a lot of consequences from this sense that China was willfully trying to misappropriate, steal, or acquire US technology. The 301 report heavily emphasized criminal enforcement. It also emphasized the role of the state behind that. So to a degree, if you want to combine the two issues together, we're kind of criminalizing the Chinese state for hacking and for other efforts to misappropriate technology. You could just do these by word count kind of studies, and we'll see this elsewhere in terms of how often words appear. The word plan appears 405 times in the 301 report. The word theft appears 119 times. The word civil enforcement appears 2 times. So this is overwhelmingly, notwithstanding that patents are only enforced civilly, notwithstanding that this was about forced technology transfer and technology issues, this was about stealing of technology, not so much, in my view, about intellectual property, even though it did identify some very significant issues. And don't get me wrong, I believe there were some very significant issues. There's no mention of a single patent, trademark, or copyright. TRIPS agreement only appears 4 times. This is really about state planning to steal, and not about the role of the courts, et cetera. So as a consequence of that, January 15th, 2020, we have a phase 1 agreement. We'll do a brief dive into that as well. I just want you to look at the picture in the back here. You have Mike Pence, Vice President, former Treasury Secretary Mnuchin, and U.S. Trade Representative Lighthizer surrounding the president, and Liu He from China when they signed the phase 1 agreement. We're going to come back to that in a moment. The phase 1 agreement had as a priority area trade secret misappropriation, including improving civil enforcement, but especially including criminal remedies, and some other IP-related issues, pharmaceutical-related IP issues, geographical indications, trademarks, et cetera. There were special campaigns. And for the first time, according to USTR, anyway, China agreed to end its longstanding practice of forcing companies to technology. Now, there's a bunch of literature out there, we really don't have time to talk about it, that suggests the US concern over FTT, forced technology transfer, was exaggerated. Dan Prudhomme, who teaches in France, has written several articles and done several presentations around this topic. I'll only say at this point that when the USTR said for the first time in any trade agreement, China was prohibited from conditioning market access on forced technology transfer is wrong. It's in the conditions of China's joining the WTO that they would not condition market access on technology transfer. But nonetheless, the Trump administration wanted to take credit. Criminal enforcement, though, very important. And again, we map it out. We compare it to the 301 agreement. Crime or criminal appears in the phase 1 agreement 19 times. It's actually, as you'll see, something that Trump and Xi Jinping agree about. There needs to be more criminal enforcement. China does a lot more criminal enforcement than the US, but Xi Jinping agrees. China should strike at this issue. The word civil appears 1 time, court appears once, only pharmaceutical patent issues are discussed. No reference to all of these other high-tech issues, which were so important around this concern about China's industrial policy and plans made in China 2025, and artificial intelligence, standardization, software development, all these other issues, not really in there. It's not in the phase 1 agreement. Might have been in phase 2, but we don't know what's happening there. An increased, bottom line, an increased role for criminal enforcement, very little on promoting markets. And really what you have out of phase 1, in my view, is an enhanced role for the government in private property rights through increasing things like criminal enforcement and administrative campaigns. And campaigns in particular, where China has this, if you will, kind of a IP police that will issue kind of misdemeanor light sentences for IP infringement in order to stop infringing. It was actually enhanced in the phase 1 agreement. It's kind of a quasi-criminal remedy. There were 4 separate campaigns that China promised to undertake in the phase 1 agreement to address customs issues, imports of infringing goods, on physical markets that sell infringing goods, counterfeit medicines, and health and safety risk products. These are all supposed to be the subject of reports. The reports were, 2 of them were supposed to come out about the time of the Democratic and Republican conventions. I don't know anything about what happened to those reports. It's been rather silent. The important thing, though, is that there's a lot of literature in intellectual property and in many other areas, including criminal law, environmental law, tax law, that special campaigns rarely have any durable effect. They're highly transient and they repeat themselves. I tend to be very cynical about them in IP. I believe that in general, the temptation for any late-term administration to support a short-term campaign in China is great because it generates impressive numbers, even if it doesn't have durable effect. With respect to software, which was one of these campaigns, this was the 23rd commitment by China on legalizing software through a campaign or other efforts. So what more did it add? Is it old wine in a new bottle? And the residents in China on some of these issues, I kind of gave you a hint of this, but in January, last month, end of January, Qiushi, the leading party journal, published a speech by Xi Jinping that came out of a party meeting at the end of November. It's a really interesting speech. It's accompanied by another article by the head of China's IP administration, and it's about strengthening IP protection. The first thing I have to say about this, by the way, and of course, some of you might find it rather tedious to read these kinds of official speeches. This is, I don't think there's been a speech on intellectual property by a US president that comes close to this ever, with the possible exception of the speeches that Abraham Lincoln made before he became president on the importance of the patent system. So even if I'm critical of Xi Jinping, I'm also really jealous that he can give such a deep speech, albeit politicized, and that he would sit through a day or 2 of meetings around intellectual property. It kind of shows the depth of understanding that China is cultivating around these issues. There are 4 elements to this speech, in my view. One of them is especially important to this theme of weaponizing IP, but they all are important to know. One is that China is going to build a higher quality IP system with higher quality IP rights. The word quality appears 11 times in the speech. It appears 16 times in the article by the head of China's National IP Administration. China is moving away from a quantitative IP regime, how many patents are filed per 10,000 people, to one where patents and other IP rights are being supported because of their value and the role they play in a more market-oriented economy. Repeatedly saying we're moving to China's moving to a system of IP creation, higher value. And you can see that in the past 10 years, this is data from the 5 largest IP offices, the growth of China's patent regime has been enormous. China is larger than all the other patent offices combined. How much of that is high quality? Probably not that much. And for that reason, we often misestimate where China is headed as a competitive threat. But anyway, it's an important thing to note. Second thing is Xi Jinping emphasized sovereignty, technological sovereignty or technological nationalism, the importance of creating China's own intellectual property rights, strengthening independent research, improving IP in new fields like big data, AI, and genetic technology, all of which, with the possible exception of genetic technology, are not in the Phase 1 agreement, promoting extraterritorial application of China's laws, a recipe for conflict with other legal systems, and we're seeing that, not in the Phase 1 agreement, and controlling foreign-related risks. Okay, so sovereignty, control of China's technological resources, its ability to innovate, also very important. Enforcement, and here we come to a meeting of the minds with Donald Trump. Resolutely punish infringements, introduce punitive compensation, deter illegal infringement, improve criminal laws, intensify criminal crackdowns, strengthen legislation. The message clearly, China is going to leverage a criminal punishment system to improve its IP regime. It's something that China shares, Xi Jinping deeply shares with Donald Trump. Interestingly, China has a more comprehensive approach. And whereas elsewhere in this litany of 4 issues that I just showed you, you have China, Xi Jinping repeatedly saying it is necessary to crack down, to have more deterrent penalties, to improve quality. When it comes to discussing the courts, it's matter of fact. China has established IP courts. The Supreme Court has established an IP court. China has central and unified management of IP categories. And the only thing he said is it's necessary to improve the IP litigation system, improve the adjudication of technical IP rights. He doesn't view the courts as requiring as many necessary reforms. And frankly, I think he's right, at least from a Chinese perspective. What is regrettable in the Phase 1 agreement and the narrative around IP theft in the 301 investigation, all of this tremendous amount of activity that has happened in China over the past several years involving technology and IP are not engaged in, are not discussed by the United States. In fact, if you took away the Phase 1 agreement, you would have to say the past 2 years in China have been a period of remarkable IP achievement. Phase 1 agreement added to it, but even without that, every major IP law has been revised. Patent law, trademark law, copyright law, trade secret law, civil code, as well as many other related regulations, new tech transfer regulations, and there's going to be new antitrust rules coming out, and a new antitrust law coming out, all dramatic changes. New IP courts, new IP tribunals. The newest court is coming up in Hainan to support the RCEP and supply chain issues. Case law has been introduced into the legal system. As of November of last year, a national system of IP prosecutors, very similar to what the Department of Justice has. Rapid growth in IP agencies. This has been a remarkable period of growth in China's IP system and kind of incorporation of IP appropriately or inappropriately into China's economic DNA. So this was kind of happening despite the Phase 1 agreement, or perhaps spurred on by the Phase 1 agreement. I think I actually give the Phase 1 agreement for kind of providing the initial incentive for China to address a range of IP issues, but most of these were not within the scope of the very limited range of negotiations around intellectual property and IP theft that existed between Xi Jinping and Donald Trump. So if you look at the Biden administration now, it's really thus far building on that legacy. And I think that's kind of regrettable. Janet Yellen, who when she was asked on CNBC February 18th, a week ago about where the Biden administration is heading on IP issues with China. She said, it's not just trade, but we're concerned about forced technology transfer, subsidies, et cetera. So remember that earlier slide I showed you with Mnuchin on signing the phase 1 agreement? Here we have another Treasury Secretary engaged in an IP discussion. This is really interesting. Beginning with Hank Paulson, we've had every Treasury Secretary engage on intellectual property to some extent. Often, I would say, with, let's say, awkward consequences. They really do not know what a patent is, and they really do not necessarily know what technology transfer is. But nonetheless, Mnuchin was there at the signing of the phase 1 agreement. If you looked at that slide or any other slides of the negotiations, you will not see a senior U.S. Patent and Trademark Office official at the table or in the audience. And nor do we hear one at this point in time. So U.S. Trade Representative, obviously very important. Robert Lighthizer was in that earlier slide. Catherine Tai, the nominee to be the U.S. Trade Representative in confirmation hearings yesterday. She did not mention the word intellectual property nor IP theft. She did say that China had to be accountable to its promises, to handling that we had to compete with China's model of state-directed economics, and we needed a united front of U.S. allies. Now, during Tai's previous tenure at USTR, the Obama administration did not launch any IP-related disputing with China. And in fact, the Trump administration, for as much as I'm a critic of it, did launch a WTO dispute on tech transfer, which involved about a dozen countries. So by that measure, actually the Trump administration developed a united front on a particular issue, surprisingly enough. So, we got to pierce the rhetoric here. Not only what you say, it is what you do. And at least with respect to this issue of forced technology transfer at the WTO, Trump administration did okay. We still need to see who the players will be on intellectual property. Now, why is that important? Right now, we have a highly weaponized approach towards intellectual property. For many respects, it's inconsistent with US values. It affects the way we engage. It orphans issues involving civil courts, patents. It results perhaps in exaggerated loss figures, perhaps relatively opaque procedures, typical of criminal enforcement. It elicits some kind of counter response. It heightens the hyperbole on both sides. It makes everything revolve around theft-based analysis. It's not really the full scope of IP issues. And it omits a lot of things. And I just want to end to show you a couple of slides about what China has done over the past few years that may surprise you. I mentioned all the legislation as kind of existing on a separate path, if you will, from this IP theft narrative, with notable exceptions involving criminal IP. But what has happened in the courts where patents in particular are being litigated? And you can see from these two studies, and there are several more, that generally foreigners do well in the Chinese courts on patent litigation based on published cases. So foreign patent cases, 80% win rate, according to Brian Love, a professor at Santa Clara, teaches IP law, compared to a domestic win rate of 67%. Very small cohort, but nonetheless higher. Bin Rendrun, who looked at 2014 data, she was a JSD candidate at Berkeley, showed that the foreign win rate was roughly 84% on patent disputes compared to a domestic win rate of 80%. The foreign is winning more than domestic companies, and in fact, winning at a higher rate than they would in their own country. And it's not just true of patents. Remember the software discussion I mentioned? 23 different negotiations between the US and China over protecting software. Well, if you look at the period from 2010 to 2019, the win rate for Microsoft on software piracy cases, 63 cases, 63 wins, 100% win rate. And it was the same for Siemens, Autodesk, and Dassault. This is a very high win rate in the civil courts. Again, not part of the discussion around IP theft. I'm not saying there aren't real issues around China's economic environment, but actually the courts aren't doing too badly in trademarks as well. The lower chart, you'll see that in certain courts, the pink side, the red side, foreign is won at 100% rate as well. You can't do better than 100%. And Max Goldberg, who's now a student at Yale Law School, looked at one court, the Beijing IP court, and he saw that in 2015, foreigners won 100% of the time across all IP rights. A lot of data around this. This is a surprisingly good win rate based on the available data. We can discuss whether the data is complete or not, but it's also a partial story. There are areas of technology that are of real concern. Pharmaceuticals, for example, the Patent Office invalidates foreign pharmaceutical patents at a far higher rate than Chinese. So the result is about 9% of foreign pharmaceutical patents get supported through the Chinese Patent Office compared to about 40% of Chinese. So you do have the arms of the government perhaps at work biasing against particular technologies. But overall, foreigners do pretty well. If you looked at these slides when you want to get them from UCSD later, you'll see that on almost every other technological area, foreigners do pretty well. This is from a database called DARTS IP that analyzes patent data from all over the world. The importance of the courts of civil remedies to protect IP and its relationship to this kind of IP theft rhetoric cannot be overstated. It threatens to impair the protection of IP as a private right, the ability to enforce it based on transparent databases, access to information, skilled court judges, and fair procedures is really critical to promoting technology. And I just want you to glance, as my last statistical slide here, at this chart, which shows publication of US IP cases in China involving an American party from January 2014 to September 2019. Now, you remember I said keep those dates in mind for the trade war. January 1, 2018 is about the middle of the trade war. Those three colored lines correspond to patent, trademark, and copyright cases. At January 1, 2018, publication of American IP cases stops. It utterly flatlines. You'll see the arrow going down there, January 1, 2018. Transparency is a political act in China. And we need the Chinese courts to publish their cases, to publish them accurately, because most of these rights will be protected or protectable by civil remedies. And to the extent the courts abide by some notion of precedent, to the extent they're open and transparent, we see that foreigners can strategize. And not only that, the data suggests that in most cases, foreigners do pretty well. So there's a balance here to be struck between the trade agenda, this focus on IP theft, which has great rhetorical resonance, doesn't necessarily correspond to what happens on an everyday basis. And also the overwhelming importance in a system that has a long history of being based on private rights, of ensuring that those private remedies, which are so critical to protection, enforcement, commercialization, fairness of treatment, are supported and made transparent so that the individual companies who secure them can protect them in the best way possible. And with that, I end my discussion on weaponization of intellectual property. And I hope we have some interesting questions, criticisms, and observations.
Thank you, Mark. That was fascinating, and I think we'll take as proven the assertion that American attacks on China are often intellectually incoherent and bundle together all sorts of things. There are some great questions queued up. But before I turn over the microphone power, let me ask you one big one. If we're doing it wrong, what should we be focusing on? What would be your kind of quick outline of an American approach that actually focuses on the most important issues?
Yeah, so I think this is like a multidimensional type of question. I tend to focus a lot on information and how the government is organized. If you have trade officials that are coming out of the Senate Finance Committee dealing with IP, they're going to be very wedded to a trade agenda, rather than if they came out of the Judiciary Committee nominating process, which has jurisdiction over intellectual property. And what we've seen is that IP, to a degree, has been a bit dumbed down and focuses on these high-profile issues, in large part because of a USTR who sits in the White House. It's very politically receptive. It has responsibility for a broad range of issues. And the consequence is that we really don't have the depth of understanding or engagement that we need in the US government. But I would really like to see a lot more coordination, integration of the resources of the Patent Office and science-based agencies of the US government into the trade agenda. And for example, if USTR had a deputy who really came out of the IP community and not out of the trade community, that would be enormously helpful. I think Catherine Tai is absolutely right that we have to look at state-driven economics and trade, and that applies equally to intellectual property. In terms of the engagement with China, I think that no matter what happens bilaterally, as long as American companies are continuing to invest in China, file patents and trademarks and litigate, we need engagement. It's not because we're being weak, it's simply because it helps our companies. So I think that we have to find the right process for engaging China, and I think it should be ramped up, certainly from pre-existing levels. I don't think the WTO is completely irrelevant. I think the case that the Trump administration filed actually went pretty well. I think there are any number of other cases that could have been filed. I think it was perhaps prematurely dismissed. And of course, working with allies is very important too. I mean, there's nothing strikingly new in the toolbox, except for the fact that I think we need greater depth and organization in the US. And I tend to think, at least in IP, there's not a decoupling versus engagement kind of discussion. It's not black and white. There's lots of levels of gray. There are areas we haven't dealt with where we need to be very strong-willed and aggressive, perhaps. And there are other areas where we probably don't need to be as aggressive as we have been.
Thanks. Following immediately on your point about WTO, Maria Vasquez has an interesting question. She points out that China brought a case against the U.S. at the WTO in 2018 because the U.S. had imposed tariffs to counteract IP theft, and China won that case. What's your view on that, and what's the follow-up on that particular case?
Yeah, so it'd be interesting to know how USTR wants to handle that one, because the U.S. has blocked appointments at the appellate body. Biden wants to be more multilateral in his approach, yet we have this decision from the WTO hanging over our heads. And we also have China acting kind of as America used to act, signing onto the RCEP, the Comprehensive Agreement on Investment, and making very positive sounds about joining the TPP, the new TPP. So the Trump sanctions certainly violated, in my view, U.S. obligations to extend, most favored nation treatment on goods, absent a decision from the WTO that would have permitted us to impose tariffs, compensatory tariffs for violation of WTO disciplines. So I feel, and in a certain, regrettably, I think that the WTO decision kind of indicates my position that the Trump administration didn't test the WTO on these IP theft issues appropriately, before it took unilateral action. It was impatient. And there were any number of claims that could have been made involving the TRIPS agreement and other agreements that at least would have made the case either the WTO works or that we're facing a different kind of animal here where the WTO doesn't work. And for that reason, at least morally, if not under WTO rules, we had the high ground in imposing sanctions. This is now another weight on our back in terms of if we want to engage with our allies at the WTO or elsewhere on IP-related issues. RCEP is a very interesting counterbalance to that because to the extent the appellate body is blocked and you have Japan, Korea, Australia, many of our allies in RCEP, and there are WTO issues, they could be litigated amongst those members in the RCEP. They don't have to go through the WTO mechanism. So
is there a mechanism in RCEP to do that?
There is a mechanism. It's a little weaker than the WTO mechanism, but there are these parallel institutions being set up, and the U.S. is not part of them.
There are a couple of really interesting questions about sort of the context of the data that you showed on IP litigation, IP criminal cases in China. And I don't want to bundle them all together, but I do want to alert you that there are going to be a couple of them. The first comes from Nick Lardy, who asks, it used to be true that the penalties in these cases were exceedingly small. So you might win, but so what? Is that still changing? I mean, is that
damages,
still, or is it changing?
Damages are low. Punitive damages have increased significantly. Damages are largely irrelevant because in 99% of all patent cases, they use statutory damages. But when you have an IP case that typically concludes in the case of patents in 7 months, courts don't want to get involved in calculating actual damages. So the result is you have these very low statutory damages. They've been going up, particularly in trademarks, somewhat in patents. I think that misstates what's happening, though, to only focus on the damage calculation. Because when you shop, if you will, for litigation in China, you're not shopping for damages. We all know they're low. Sometimes they're hard to collect on, even though they've increased. What you're getting is a rapid decision, 7 months' time. It's going to take years in the United States or anywhere else. And you're getting an injunction where, in all likelihood, your adversary's products are being manufactured or sold in China. So the value of that injunction is enormous. When Qualcomm sued Apple globally in a global IP dispute they had, the first court to issue an injunction was where? Fuzhou, ahead of Germany, ahead of the United States. And those injunctions can bring an adversary, commercial adversary, to the negotiating table. So the IP system, yes, it's deficient on damages, but is it useless? Absolutely not.
And a couple of questions, one by Mark Dallas, from Mark Dallas, that asked, to what extent does the trade-off between criminal and civil venues in China affect some of these outcomes? I mean, is there, do we see a more assertive criminal courts in part because the civil channel is underdeveloped?
Yeah, so first of all, the civil docket is huge in China. I mean, even though the criminal docket is much bigger than the U.S., the civil docket is also much bigger than the U.S. It was roughly 400,000 cases last year. I think the U.S. was maybe 10 to 15,000. You're looking about a 30 to 40 multiple over the U.S. docket. There's basically 3+ interacting mechanisms here, the way I like to think about it is that it's kind of a market for IP enforcement services. If you have an infringer, you can go to the civil system, which is relatively transparent, give you modest compensation and get an injunction. You can go to the criminal system, which, even though it's a public enforcement mechanism, is expensive. You have to work with the police, and you're not going to have control over the outcome. The police and prosecutors will do what they want. You can go to the administrative system, which is even, gives you a lighter fine, but can often have power locally. And they all interact. So you can see statistically that, for example, traditionally, China's administrative trademark system had a lot of foreign cases. Foreigners like to bring cases there. And there were very few foreign civil trademark cases. So it seemed to be that if you were in the market for IP services and trademarks, you might use the administrative system because it's all over the place, they're cooperative, and they're fast. Criminal cases are really about putting someone in jail and taking them out of the market. And in particular, leveraging the ability of law enforcement to gather information that you may not have as a rights holder. Easily abused. And I think this is also really important to note as well. Huawei, for example, and ZTE have filed lots of criminal cases for trade secret theft by employees. Now, in most parts of the world, those will be civil cases. And many Chinese academics have said criminalization of trade secrets is a bad thing. This can be used against foreigners because they really should be using the civil remedy, but they want a more deterrent penalty imposed in order to keep their employees in line. So these systems do interact. I don't think the criminal courts are any weaker or less competent than the civil courts, although I would say the civil IP courts have developed a real competence around patent and related matters, which are not typically the focus of criminal.
There are so many great questions here. I'm going to try and rush through a few. Chris Israel asks, given that politically in the United States, a lot of the push on IP came from U.S. industry initially, and then got sort of picked up by the politicians. Do you see any shift in industry opinion where they sense that maybe a different approach might now start to be more appropriate?
Yeah, so great question from Chris. I think that, first of all, I think the Trump administration, and I supported this, began to integrate more of what it thought were US government interests on intellectual property and technology rather than being reactive to or relying primarily upon industry requests. And the consequence of that really in the past was that the patent community tends to be pretty quiet on trade issues most of the time. And that's probably, and the copyright community, motion pictures, music, software tended to be a little bit louder. And that's basically where our trade discussions were. I think what we've seen now with a greater concern over industrial policy and national competitiveness, and the greater interest in the US's own interests and not simply relying in a reactive way. How does industry feel about this? Sometimes industry does want to be regulated, to take it out of their own hands. Whether we're at that point or not, I can't say. Industry continues to invest in China. They continue to file patents in China and trademarks in China. I don't think they're decoupling on innovation and tech issues as much as the Trump administration had prodded them. So if there are going to be some changes because of some deeply felt national interest, it would probably have to come from the government. I think there's room for greater partnerships, though, in terms of information sharing and the like. I don't think industry is in a position to anticipate China's economic development the same way that the government could through aggregating data and the like. And there have been some really interesting white paper, transition paper proposals about using patent and scientific publishing data to anticipate competitive challenges or national security challenges and the like. And I think that government has an important role to play in working with industry and sometimes pushing industry along in terms of looking at competitive challenges, particularly those that would affect national security.
That's extremely interesting. Rather than pursuing that angle, we're already over time. I know people are going to have to start leaving. Mark has kindly agreed to stay sort of another 5 or 10 minutes, just so we can ask a few more questions. And there's a really interesting one from Jeff Lehman, who, looking at TV film, he says, look, the problem in the past was just that there was no aftermarket protection. Everything was pirated. Is this changing, and what should we do?
So, the film industry is a great barometer of how monetization of IP is changing. And I think one of the biggest changes for the film industry came out of real estate and the development of high quality multi-screen theaters and shopping malls. And people decided they wanted to go to the movies, and you couldn't have that theatrical experience, watching a pirated DVD, even on your large screen home theater. And the result was that there's been a licensing bubble, that there had been more and more commercialization of movies. China lacks a diversity of revenue streams in the movie industry, like in the U.S., where you have your theatrical release, your cable TV release, you have your DVD or the like, and other streams, including merchandising of products. But we have seen companies like Alibaba take exclusive licenses, Alibaba Tencent, take exclusive licenses over music and movies. And Eric Priest at University of Oregon has written a lot about this. The market has become a lot better. And as you've gotten these exclusive licenses, unlike in the US, where they're largely non-exclusive, you've seen prices go up, and you've seen the licensees deeply invested in the protection and enforcement of the rights because they bought them. So I think the IP environment for motion pictures has improved dramatically, not necessarily due to improvement of the laws or enforcement, but due to economic realities.
Here's a really a broad question that an anonymous attendee asked, and I think this person asked it in a really interesting way. So I'll just read it off. By flatly comparing current figures and facts, don't you underestimate the cultural and ideological gap between free Athens and strongly state-managed Sparta? IPR in a liberal system stimulates free competition, while IPR in an illiberal state can be a means of repression. And they go on, but I'll just throw it to you at that point.
So I don't know if the comparison is between Athens and Sparta, but and I'm not an expert on Greek history, but what we have in China is a merging of intellectual property, state-planned economies, state-planned economy. And it is not simply a tool of state repression. I think, to the contrary, beginning with 1979, the patent law was viewed as an instrument of economic reform, and Deng Xiaoping saw it that way. And in a range of areas which had very important consequences for the Chinese legal system. Intellectual property has been a bellwether of other reforms. Publishing of IP cases, case law, preliminary injunctions, specialized IP courts, transparency, open court decisions, many, many other areas were first experimented on in an IP context and had important consequences, perhaps not as important as I would hope. Don't get me wrong, China still has huge issues in its legal system, but it's been important for marital disputes, contract disputes, domestic issues, and for spurring some sense of private enterprise. Can it be a tool for state repression? Absolutely. And we've seen places where the IP regime in the hands of state-owned enterprises or powerful companies, as the example I gave of Huawei and criminal enforcement against its employees, can be used to enhance power to the disadvantage of the individual. But I think it's a bit more complicated than that. I do agree, though, with the general proposition that China has been a bit of an outlier in terms of intellectual property, because the general expectation had been that socialist or communist economies, Eastern Europe especially, would grapple with IP issues and would push them off because they barely understood property rights coming out of the Cold War. China, however, made a decision to embrace them. And I think we're still trying to understand how to handle that, whether that approach to state-managed innovation and IP is addressable by WTO disciplines or through our allies or through unilateral measures. And I think that's the big challenge. I don't think it has been as much a tool of repression as some might have thought it could be.
Although, I mean, to be fair to this anonymous questioner, I think the point was not so much that it was a tool of repression, although they did say that, but the picture might be worse than what we would get by just looking at a set of numbers. And maybe we should add to that. I mean, numbers reflect the fact that the state still decides which cases to publicize.
Absolutely.
And
I'm sorry, Barry. I agree with that. And if we had another hour or so and invited some folks at UCSD, Berkeley, Columbia, and elsewhere, we could talk about what gets published and where the numbers come from. I hope I was adequately careful in saying based on published data. The question is what is getting published and what is not getting published and how it is getting published. So for me, my operative assumption is that, as a foreigner, you can win in an average IP case. There are a lot of non-average IP cases, some with very high damages, highly politically influenced, where foreigners lose. And I know many of them. Some of them appear in 10Ks and 10Qs, the security filings in the United States. Some of them are in newspaper articles and elsewhere. And those do not get reported. And because of that, and I've told Chinese colleagues this quite frankly, all the good data that they generate gets driven out by the bad anecdotes. You have one or two really bad, atrocious cases. And I know the largest case still to this date in Chinese history where a foreigner lost a patent case, and still the largest patent damages, has never been published. So you leave it out of the data, you get a different report.
Right. Wow. We've already gone 10 minutes over. So Mark, you are not only scrupulously fair in presenting the information, you're also extremely generous in sharing your time. I have one last job. I've got to announce our next program. Please come online to china.ucsd.edu to get the latest info and stay up to date. But also in 2 weeks, we're going to have a tremendous talk. Keisha Brown has been doing this fascinating work. She calls it Sino-Black relations to encompass the tremendous complexity of China's relation with American Blacks, with Black Africa, and with Black people in China. So that should be a fabulous talk, March 18th. Thank you for joining us, and we look forward to seeing you at the next event. Mark, thank you very much for sharing that fascinating material with us.
Thank you, Barry. Thank you, everyone, for attending.